Hello, and thank you for joining us. This is No Soundbites Allowed, and I am your host, Michael Voss. Dragon of the Southern Tier, I'm happy to be here with you today. It's March 24th of 2022, and we have an interesting subject to discuss today. Now, obviously, the nation has been very much aware of the ongoing nomination of Ketanji Brown Jackson, who is a nominee for the Supreme Court of the United States. And for the last 3 days, there has been much to be seen in the Senate process as it has been ongoing. We've spoken about this a little bit before. In fact, we've been talking about the nomination by the Biden-Harris administration of a black woman to the Supreme Court because they are a black woman. But something was said, and there is a fact check on it, by Tennessee Senator Marsha Blackburn. And we want to address both the Politifact fact check and her actual statements to see if they are true and correct, and what do they mean to the American people as well as the Supreme Court. Now, before we get to that, we do want to mention, if this is the first time that you are seeing our channel, we welcome you and we thank you for being part of our audience. Further, we would want you to know that we do long-form political commentary. And every Sunday at 2:30 p.m. Eastern Standard Time, we do a live stream with you. We reach out on YouTube, Facebook, Twitter, all the internet that the internet overlords will allow to reach you and hear your tweets, your chats, and your phone calls to tell us what you think about the issues that matter to us all, that affect all of us across the globe. Because we believe in the First Amendment. We believe in your right to free speech. It is not just an American principle. It is something for everyone in the world, even if your government does not agree. So we hope to see you this Sunday at 2:30 p.m. Eastern Standard Time. So there was a lot that has been said about Ketanji Brown Jackson and her nomination to the Supreme Court. There has been, and there is, a lot of question about her placement. The fact that she was picked because she's black, a woman, the correct age, and the correct political philosophy. She has been identified by many people as an activist judge. Some have identified that she may or may not be weak on crime based on her sentencing, especially in the regards to child pornography. And there are other questions beyond that. We're going to address one of the questions beyond that. The question of critical race theory, an issue that is preeminent amongst the nation that the majority of people do not agree with. Is Judge Jackson not only a supporter of critical race theory, which we have seen she is, but more importantly, how does that influence her judgments and how it may affect the Supreme Court? So let's get into that. Now, you may have seen this on March 22nd from Politifact, and it is, quote, Ketanji Brown Jackson gave a lecture talking about critical race theory as one of the components to consider when you are making decisions on the bench. This has been rated as false. Okay, so let's look at this carefully here, because their summary is in 2015 speech about sentencing. Judge Jackson did not say critical race theory should be considered by judges in making decisions on the bench. Jackson said that sentencing policy is interesting on an intellectual level because it melds together myriad types of laws as well as critical race theory, negotiations, and contracts. That isn't correct. That isn't what Judge Jackson said in 2015. And we're going to go over exactly what she did say and look at what that means. But before we do so, we want to look at what did Marsha Blackburn, Senator Marsha Blackburn, say today, March 24th, so that you can hear both sides of this that we want to address. She said, in part,
her judicial philosophy, that concerned us. There's another thing I want to ask you about. This is where she talked about CRT in sentencing. This was from a 2015 speech. And I felt like this was really inappropriate. I also try to convince my students that sentencing is just plain interesting on an intellectual level, in part because it melds together myriad types of law. Criminal law, of course, but also administrative law, constitutional law, critical race theory. Is critical race theory a type of law, Ms. Mascott?
Well, Senator Blackburn, I teach a number of courses at Scalia Law School, and none involve critical race theory, so I would not be the best expert on that. As far as sentencing,
I stopped there for a reason. Because the answer, which in part is critical race theory, is not law, which should have been the answer by Ms. Mascott. But what is more important is the question that was asked by Senator Blackburn. That question being, first, is critical race theory a law? Which we can definitively and without question answer no. But then let's put this in context, especially when we have to consider the context that was raised by Politico. That in reference to the speech that was being given, was this a directive towards judges? And how does critical race theory apply as a factor in sentencing? I want to be very clear about that. Now, in the Politifact review of this, they are very clear to state, to give us part of the speech, which they do link to. And therefore, they say that their ruling is Senator Blackburn claimed that Jackson in 2015 gave a lecture talking about critical race theory as one of the components to consider when you're making decisions on the bench. Jackson was speaking about sentencing policy, not how judges make decisions on the bench. She said sentencing policy is interesting on an intellectual level because it, quote, melds together myriad types of law, end quote, as well as critical race theory, negotiations, and contracts. We blame Blackburn's statement as false. Was it actually false? Was what Ms. Blackburn asked incorrect? Well, let's actually go to the document itself. And what we have here, as linked by Politifact, as submitted to the United States government and in the Senate, is the actual speech, Fairness in Federal Sentencing and Examination. Let's read this, the relevant portion. Now, I'm actually starting in the second paragraph, and it states, "These are the kind of questions that I have grappled with for years, first in my role as the staff of the United States Sentencing Commission, then as the vice chair and appointed member of the Sentencing Commission, and even now in my current gig as a U.S. District Judge. I have also had the good fortune of being able to teach a seminar on federal sentencing as an adjunct professor at a law school in my area and in my class. I have one basic goal, to persuade my students to think about federal sentencing not as an oddly narrow area of focus that is tackled onto criminal law, but instead as a vast area of inquiry that is well worth studying all its own. In fact, if you were to take my class, you would hear me tout criminal sentencing as among the, quote, don't miss, end quote, courses and subjects in law school, not just because I teach it, but because I, for one, believe that sentencing law and policy is one of the most important things that any budding lawyer, and for that matter, any seasoned practitioner, can study. Why is that? Well, there is the practical reason that, as you know, no fewer than 97% of the cases in the federal criminal justice system are now resolved by guilty pleas. So in the vast majority of criminal cases, sentencing is really all there is. But even beyond that, learning about sentencing is important for all lawyers, even if criminal law is not your thing, because at the bottom, the sentencing of criminal offenders is authorized exercise of the power of the government to subjugate the free will of individuals, which in and of itself has enormous implications in a society in which the government derives its power from the will of the people. Dostoevsky put it this way, quote, "You can judge a society by how well it treats its prisoners," end quote. So as I see it, becoming well-versed in how our government exercises its power over people who breach its commandments is essential to sustaining our very democracy. Quote, I also try to convince my students that sentencing is just plain interesting on an intellectual level, in part because it melds together myriad types of law. Criminal law, of course, but also administrative law, constitutional law, critical race theory, negotiations, and to some extent even contracts. And if that's not enough to prove to them that sentencing is a subject worth studying, I point out that sentencing policy implicates and intersects with various other intellectual disciplines as well, including philosophy, psychology, history, statistics, economics, and politics. So in looking at what we have just read from the words and mouth of Judge Jackson, first, is it correct, as stated by Senator Marsha Blackburn, that critical race theory is law? It is not. That is an absolute. Even though the person she asked then declined to answer that, the answer is very straightforward. It is not law of the United States. There is no question on this. Let's look again at the words and the context directly. She stated, in part because it melds together myriad types of law. She is speaking specifically about types of law. And she says, criminal law, of course, but also, so we're again speaking about types of law. She goes on to say, Judge Jackson says, administrative law, constitutional law. She is defining and identifying specific types of law. She mentions critical race theory, negotiations, and to some extent, some even contracts, contract law. Negotiations aid and abet both contracts and administration. Therefore, administration law and contract law. So, in context, when we are listening to the words of 2015 Judge Jackson, we are hearing her talk about law, specifically about laws and those things that aid and abet laws. To say strictly that she has mentioned critical race theory as a law is not correct. To say that she is inferring and indirectly stating that critical race theory is as important as contract law, criminal law, and administrative law and constitutional law is correct, because she did, in fact, put that in that same grouping. So if a lawyer and or a judge were to be considering sentencing, they must consider these significant factors, that they have equal weighting or are generally weighted together: contracts, negotiations, and administrative law, constitutional law, criminal law, and critical race theory. She is equating the power of critical race theory, an idea, to the same degree as laws, and the function of those laws, such as negotiations, which contribute to contract law and to administration. So she's not directly correct, but she is indirectly correct. That is the substance of what Judge Jackson is saying. Now, I'm not an attorney, nor was Judge Jackson making a legal statement. She was making a speech. So I don't have to be in law school to be able to look at the speech and to try and understand the words. We merely need to understand English and using our comprehension of English to understand the words she is saying. We'll come back to this. But I also want to look at Politifact, which took on and made a statement on March 22nd that Judge Jackson gave a lecture talking about critical race theory as one of the components to consider when you are making decisions on the bench. Now, let's be very clear. The exact quote from Senator Blackburn was, whether you're in Virginia, whether you're in San Francisco, you want children to be taught facts in school. You don't want them to be indoctrinated. And she went on to say, Jackson gave a lecture talking about critical race theory as one of the components to consider when you are making decisions on the bench. Well, again, let's take this fully and truly in context and understanding. The speech that is being made, Fairness in Federal Sentencing, was being made to, as stated by Judge Jackson, that this is something to be considered by lawyers, by students, and that she herself, as a current U.S. District Judge, considers. These are the things that she considers. This is what she is using as part of her policy on sentencing. It is an incredibly important thing, and it is something that she teaches to future lawyers as students and those in law school, and something that she advises for lawyers no matter what type of law that they look at. This is all encompassing. Judges come from lawyers. Therefore, she is speaking to lawyers, judges, and students. She wants everyone in the legal field to consider sentencing at every step. That is her statement. That is why she emphasized this. So to say that this is one of the components to consider when making decisions on the bench, that is a derivation. That is true. But it is derivation based on the actual statement from Judge Jackson herself in discussing herself and her current position then in 2015 as a U.S. District Judge. So it is fair. It is a fair understanding of the statements and the context those statements were being made in 2015. By Politifact, to say that that is not true is not correct, because they are taking this out of context. They are missing the very section that puts it into context. We do understand what Senator Marsha Blackburn is saying, and it would be in that context correct. Politifact is not correct, and maybe the correct ruling from Politifact, instead of saying that this was blatantly and completely false, perhaps they should have said instead that this is partially false, or depends on the context and the understanding, that this is something that you can derive from the very words of Judge Jackson based on her speech, though it is not a direct statement. It is not a direct quote. But we mentioned something else that I think is important, which is the policy, the philosophy of Judge Jackson, which is at the core of the question in the Senate hearings at this time. What does Judge Jackson believe, and how does she go about her duties as a judge and potentially as a justice on the Supreme Court? Well, what is a policy? The definition of a policy, according to Merriam-Webster, is a definite course of or method of action selected from among alternatives and in light of given conditions to guide and determine present and future decisions. Management or procedure based primarily on material interests. So the policy of Judge Jackson, as we have seen, is to look at sentencing as a critical and core part of the decisions that she makes as a judge. That this is an intrinsic and vital part of the entire process. And that as part of that process, to consider with presumably equal weight, or at least equal seriousness, law, such as criminal law, administrative law, constitutional law, contract law, and those things that affect those laws, which would be negotiations, and a theory, critical race theory, which is neither a law nor an application of those laws or to enable those laws. Critical race theory is a theory. It is a presumption of a racial bias intrinsic within the institutions of the United States, and in some, according to some of its authors, the United States itself, including the Constitution. So her policy, which also is defined looking at Wikipedia, is a deliberate system of guidelines to guide decisions and to achieve rational outcomes. A policy is a statement of intent and is implemented as a procedure or protocol. So it is the rational outcome is guided by critical race theory, according to Judge Jackson. That critical race theory is a statement of intent as a procedure and a protocol when making decisions in terms of sentencing. So critical race theory is part of the policy of Judge Jackson. That we can determine from her statements in 2015 because of the weight of what she is saying, because of the words that she have, the types of law that she has put together here. And while it is not true that critical race theory is law, it is correct to say that in 2015, Judge Ketanji Brown Jackson is giving critical race theory the same weight as law, that it is as important as constitutional law, that it is as important as criminal law, that she feels that her policy is, the procedure is, that it must be evaluated, it must be part of that process of sentencing, that race is a factor of the punishment of someone who has been duly found criminal. And I am very sure that there is not going to be a large discussion on this matter. Politifact has silenced many people on this, that many people will go to Politifact and stop, that many people will hear the rebuttals from CNN, MSNBC, the talking heads on the major media networks, which are predominantly left-leaning, as has been seen in poll after poll, study after study, that they will hear this and they will say, well, then it's not true. And they will discount this without ever actually going back to the document itself and to see what is being said and in full context and to understand for themselves what this means. And to say flatly with Politico that it is not correct is wrong. She's speaking to current students, she's speaking to current and future lawyers, and she is speaking to current students, lawyers, and future judges. That is the weight of what she is saying and who she is directing her comments to. And she knows this. This is done purposefully. And she is using her role as then a U.S. district judge for the weight of her statements to, as well as a teacher, to push the importance of the criteria she has listed in considering any and all sentencing. I think this should make many people concerned that an individual being considered for the Supreme Court views, apparently, at least as significant, if not more significantly, critical race theory, an ideology created over the last 40 years that is not accepted as fact, to be equal to constitutional law. Judges have a wide berth in America. They can make many decisions based on their own criteria. That is the nature of our judicial system. And so judges can take into account many factors of their own without really any question or any challenge, although they can be overruled when they have overstepped their bounds, which we have seen Judge Jackson do over the last 9 months. Is critical race theory a significant factor for Judge Jackson? Yes, she has said so. She sees that as important in the private school and where she is a member of the board in instructing the next generation of children. Now, she says she's not aware of that. Then why is she on the school board? We have great difficulty believing she was not at least aware of the material that was being assigned to students as young as 5 years old. You may disagree with that. Fair enough. But there is no question that when she is speaking to future lawyers, current lawyers, and future judges, she wishes to impart that critical race theory is a significant and critical factor that must be included in all decisions. In our opinion, any type of law increases the net belief that any group of people are less than. We feel is both discriminatory and prejudiced, and should not be a factor in the United States in terms of our legislation, nor in terms of our judiciary. You may disagree. We look forward to hearing what you have to say and looking at the full context of what was said by Judge Jackson and taking that into account, looking at what Politico decided and what was stated by Senator Marsha Blackburn. And we also invite you to join us every Sunday at 2:30 p.m. Eastern Standard Time to talk about this and other issues that will affect everyone. We thank you, and we look forward to seeing you soon.